This is Apropos. Supporters of the legislation are hopeful that it will help to deter and raise awareness about marital rape. Lawmakers here in France have moved to abolish the concept of marital duty, the antiquated notion that married couples are required to have sex. With the details, here's Monty Francis.
For 20 years, Ingrid was married to the same man and felt pressure to have sex with him under a legal obligation.
He said, "She's my wife, so that's it." When I said I didn't want to, he said he would take a mistress, that he would look elsewhere. So those were the threats. When I didn't want to, I was punished.
Ingrid is not alone. A recent survey found that more than half of French women reported sex with their partner that was either forced or coerced. On Wednesday, the National Assembly passed a bill doing away with any legal obligation to have sexual relations within marriage.
I would also like to spare a thought for all the women who were forced into sex, who suffered marital rape, who were coerced into sex when they didn't want to be, and we're counting on this text to be a starting point for ensuring that this ends.
Although not explicit, the current civil code requires spouses to live together, which is often legally interpreted as an obligation of marital duty. Last year, the European Court of Human Rights ruled against France and in favor of a 69-year-old woman whose husband obtained a divorce on grounds that she was at fault for refusing to have sex with him. The proposed changes to the civil code would make granting a divorce on such grounds impossible. The bill adopted by the Assembly must now be examined by the Senate.
For more, we're joined now by Michele Goodwin, Professor of Constitutional Law and Global Health Policy at Georgetown University. Thanks so much for being with us on the programme this evening. Firstly, people may be surprised to learn that such an outdated concept still exists. But as we heard in that report there, surveys finding that more than half of women here in France, in any case, reported sex with their partner that was either forced or coerced. So how big of an issue in the modern day is marital rape?
It's a very significant issue, and its history goes back centuries. In fact, there were judges, lawyers, those who authored legal case books that promoted this idea that women had no independent identity apart from their husbands. This was called coverture. And within the context of coverture, women were property of their husbands. They had no independent identity. And the idea was that a man cannot rape himself, which is how these issues were resolved. If a wife claimed that she had been raped by her husband, the law was that's impossible because she doesn't exist and he cannot rape himself. And we've seen the tragedy of cases across time, across different countries, and even here in the United States with really horrific facts, and yet women not able to prevail. And we've seen cases even where the woman has filed for a divorce, but the divorce has not yet been granted, where she's been confined, abducted, raped by her husband, and courts have said that's not rape because she was still married to him because the divorce had not come through.
And when it comes to cases like this, and also the one that Monty referred to in that report back in 2019, when a man obtained a divorce on the grounds that his wife had stopped having sex with him, it was later repealed by the European Court of Human Rights. But would a judge not be more likely to kind of interpret all of this with an ounce of common sense rather than prescribing absolutely to the word of the law?
I wish that were the case. I've written extensively about this, and I even conclude the epilogue. The epilogue to my book, Policing the Womb, deals exactly with these questions because it is absurd. It reflects on judges not using their authority or using common sense or even equity within law to provide a sense of justice, to provide substantively justice for women. And it's affected then not only women who are married, but this kind of precedent in law has also affected other areas and aspects of law with women who actually happen not to be married, and even with girls. So we take this principle of marriage as protecting men who rape their wives. Well, this then also extended to other areas where fathers who rape their daughters. We've seen in law where there has been considered spousal immunity, such as when a man has raped his wife, she cannot sue him. But then there has grown into law based on this family immunity, where a father who's raped his daughter cannot be held liable. And in these cases, they're really quite extreme, where judges have said, well, this would be very disruptive to the household if girls were able to sue their fathers after rape. It's extraordinary. And yet here we have this, even in state Supreme Court decisions.
And Michele, do legal systems then in themselves contribute to the kind of shaming, stigmatization we see of victims when they do come forward? You say that in many cases, legislation, it hasn't only failed to prevent marital rape, but it's actively enabled it in some cases.
That's absolutely right. And when we look at the history of women's exclusion in society, exclusion within law, exclusion within legal education, and more, then what we have are legislative bodies over time that have been male dominant, that have excluded women, and where even when women have been included, women have not necessarily been appointed to the key commissions or the key chair positions where they would be able to bring issues like this to the forefront and demand that they be addressed by their colleagues. So legislatures, judges have played a significant role in keeping women far behind. And even on that point that I mentioned about the exclusion of women, there is a Supreme Court case in the United States where a woman petitioned the court such that she could become a lawyer. Her husband was already a lawyer and she had graduated from law school. And the United States Supreme Court said, well, her place was not in law. Her place was in taking care of her husband and her children. Now, that's not why she petitioned the court. And so we see over and over again women seeking to advance their interest within society, and by law, women being held back. So this is an advancement, what is taking shape now.
So are women's rights then essentially valued less than family unity?
Oh, women's rights certainly have been. And in fact, when we think about marital rape and this law of femme covert coverture, we've seen that it's had its implications not only in the toleration of marital rape and sexual abuse in a marriage, but also with physical abuse as well, such that because of these philosophies in law, women could be sexually abused by their husbands and even their boyfriends, and as well victimized physically. The result has been courts saying that these are private matters. These are private matters that should be left to the domain of the home. And in these cases, you see what privacy means is not women's privacy, the privacy of their bodies to be protected, but instead privacy being used as a proxy that has protected male interest. And it's time for this all to come to an end. And it's a perfect thing that this is being raised on an international basis, because across countries, whether it's been in France or it's been in the United States or in the UK, these have been very serious issues.
And Michele, how do these kind of legacies, legal, cultural legacies, however you want to describe them, how do they continue then to influence contemporary attitudes, not just when it comes to decisions that are made in the courts, but on a societal level?
Well, what happens in the court certainly does send a signal to what should happen in society. And when you have enough court decisions that make it very clear that women are on the outside of the court looking in, then that bleeds its way into a society. It's something that law enforcement comes to expect. So that when we look at these histories of domestic violence, physical violence, and sexual violence within families, what you see are patterns where even when law enforcement is called, law enforcement doesn't necessarily act out what we would expect, which is protecting individuals who've been victimized. But instead, what we see historically are these patterns where men would be taken to a bar to get drinks after a woman calls and says, I've been raped by my husband, or I've been beaten up by my husband, rather than law enforcement doing what it would do if a man beat up another man. In these instances, beating up his wife or raping his wife is rewarded by him getting drinks and then, of course, coming home. What that does is to produce a chilling chilling effect. And by that chilling effect, it means that women are going to be much more reluctant to call law enforcement because they realize law enforcement will treat them differently than it would treat a man. And so it's created these very significant gaps of justice within our societies. And it's meant that it has silenced women when women have tried to fend for themselves and defend their interests.
And Michele, it also ties in as well with the notion of consent. Now, it was only last year that France actually adopted this as a principle, using it now to define the crime of rape as such. Why do you think it's taken France so long to get to this position, following in the footsteps of several other European countries?
This is a very good question because it raises issues with regard to women's credibility and women's credibility within law and women's stature within law. If a woman has been reduced to the status of mere property or significant property, then you're not thinking about the human rights, the human dignity, the integrity of this entity, which has now been reduced to the status of property. And if you've been reduced to the status of property, being perceived as having no dignity within law, then it means that you're almost invisible. It means that you really don't have a voice that the state is supposed to respect and pay attention to, which is why we can see it is taking so long to unpack these questions with regard to consent. Can property consent? Now, if you think about an inanimate object as your property, your car, your book, your laptop, well, these are inanimate objects. These are objects that cannot speak. And so it tells us so much about the depravity baked into law for so long that women would be considered the status of property, such that one does not actually have to pay attention to what they think, what they feel, or what they have experienced, which then also means that consent is meaningless. But this also says a lot about not trusting women and not trusting women's voices, that even if the scars of battle, intimate partner battle, is on her face and written on her body, law has been very slow, clearly centuries long slow, in recognizing that that should be remedied and that it should be punishable when that happens to a woman. But we've been centuries in the making of getting us there. And I can tell you there are cases that I read daily from around the world where judges are simply not doing the jobs that people would expect them to do.
Michele, we'll have to leave it there for now. Thanks so much for being with us, though, on the programme. It's a very enlightening conversation. Michele Goodwin, Professor of Constitutional Law and Global Health Policy at Georgetown University. Thanks so much.